Okay, 10 minutes gone past the hour of 5. You're still listening to Hard Facts on 92.3 Nigeria Info. Remember, you can watch us live on Facebook and on YouTube, Nigeria Info PH. And we're active on X as well. You can go interact with us there, Nigeria Info PH. That's the handle for 3 platforms. Once again, I'm Kala Korubatu and this is Hard Facts. I've got a guest. He is a constitutional lawyer. Is several things. Once upon a time, a lecturer at the River State University. He's also a political analyst. And he's on the show via the phone. And we want to talk about going to the Supreme Court. So welcome, Dr. C.A.J. Chinwo, who's got an expertise living in Nigeria. Welcome, Doc, on the show.
Thank you, Canada. Thank you very much. Thank you, listeners.
It's been a while you and I had a conversation, and so much have happened ever since then. The last time you and I talked, and I think the last time you and I talked, we talked about the judiciary. We even talked about the Supreme Court, and now we are going to the Supreme Court. However, the reason why I've called you is because there are several people who think going to the Supreme Court is a waste of time. For instance, Umahi, Kwankwaso, Clark. And they've all said the argument at the presidential election petition court was not strong enough, so why go to the Supreme Court? And so I need a constitutional lawyer to help me have a conversation and educate my listeners as well. So welcome once again. So the first question I want to throw at you is, what do you make of the judgment by the justices of the presidential election petition court? No, summarily, let's start with that.
Well, the judgment of court are ordinarily based on the facts presented before the court and the law that is applicable to the case. And of course, the perception and understanding of the court itself. Judges admit that they are not infallible, they are not perfect in knowing everything. So that is why judges can have different perspectives to a legal position. So these are things that govern it. The facts of the case, the presentation of those facts through how the facts are presented, and then the law is applicable, and the judge's perception and understanding of the law in its application.
All right.
So the Court of Appeal judgment, I think those factors may have also contributed to it. The facts that were presented before the tribunal may not be the facts that every Nigerian thinks he knows, or they may be the same facts. The law that is presented before the tribunal may or may not be exactly the same law that people may have in mind when they are making analysis. And then the judges themselves have different understanding of it. And maybe their understanding is what has led them to the decision they took. Perhaps other judges will are taking it differently.
Right.
But that is also why there's the appellate system. When one court decides, it can go to another court to verify, and then maybe go to the last court, the Supreme Court, to confirm. In this case now, 5 justices of the Court of Appeal, sitting as a judicial have decided on what they know. The matter goes to the Supreme Court. 7 justices of the Supreme Court will sit, making a total of 12 judges sitting. And I think Nigeria should be satisfied whatever comes from there. That's the way I can make out of it.
All right. Now you've mentioned presentation of facts before the justices. How you also explain or argue your matter in court. These are some of the things that can affect how a judgment comes out. Do you think that the petitioners, now I'm not pointing at any particular one because we have the PDP, the APM, and also the Labour Party. Do you think their lawyers did a good job? As a lawyer now, I'm not asking you to berate anyone, but do you think the lawyers did a good job in 1, arguing the fact, and 2, presenting the facts?
I think when the lawyers finished, I remember watching Chris Witte on television. I also watched Living on television. They were satisfied with what they did, and they were expected to get judgment. So it's a subjective thing whether any lawyer did well. He thinks that he did well. But it is the court that will look at it and say you did well or not. But on the other hand, it has Supreme Court have said long ago, since 1987, it is not the advocacy of a lawyer that makes a bad case to become good. If a case is bad, there's nothing much we can do. The only thing it will do is that A good lawyer can make the court listen to him and not dismiss it offhand. A good lawyer will make the presentation look reasonable, but it doesn't turn black to become white. It doesn't turn a face into the other. So it will therefore not be a matter for us to blame lawyers or not now. Even though the court, in giving his decision, went on to maybe blame the lawyers here and there, but all Nigerians should know that none of us watch the proceeding unless we're in that court tribunal. Incidentally, those who were in the tribunal were hailing the performance of the lawyers from Chris Tuchke, the PDP, and the lawyers of Labour Party. So you see, that's why it depends on what ultimately what the Supreme Court decides. But I want to use the also so that I noticed something. I just finished an election tribunal. I noticed that lawyers in Nigeria, we needed to work a little bit harder than we are working.
Okay.
When we are doing matters that affect the whole our clients, particularly election matter, we haven't gone to the depth of moving the court as we ought to, and that may be the reason why the expectation of Nigeria is so far away from what happened. But there's a limit to which you can blame the lawyer, and the law is that is stacked against the election petition, even though the Present Electoral Act has made some improvements over what we used to have.
Okay, so now let's go back to the Court of Appeal and look at the presentation of fact. Now, I like the way you put it. A lot of us did not see what transpired during the proceedings. We only watched the judgment, by the justices. But from what the justices said and how they painstakingly read out, point by point, do you think the right facts or right evidence or pieces of evidence were submitted to the courts by any of the petitioners, not any particular one?
Well, I think it's like I said again, it depends on the claim. Evidence is to bring support a claim. If your claim is that a person is not qualified, show how he was not qualified. It is not the same as where you are saying that the person didn't win a majority of lawful votes cast. So if you have evidence, your claim is on a particular claim, the evidence should be in line with that claim and support it. But if you didn't, then it's going to be difficult. But one thing I noticed, Canada, is that the courts and maybe the lawyers who have not realized the improvement the Electoral Act is produced.
Okay.
I saw them talking about dumping of evidence. I saw them talking about the 35 days. I saw them the court itself going to challenge IRF. That is, it's like the court itself didn't go to the point of reading the Electoral Act as it is today. And sometimes I noticed that in the position I was doing, that many of the lawyers is like, oh, this is how we have been doing it before.
Yeah.
We lawyers and the judges must begin to get interested, and of course all Nigerians will begin to get interested in reading legislation. When new laws are made, we should go and buy it and read as you read newspaper. They are not too technical. Laws are not made in languages that you cannot understand. We are not in that era of thou and heretofore and heretofore. They are just use simple language. Nigerians should make a habit of buying the laws that are made by the Houses of Assembly and the National Assembly and read them. Because, like in this Electoral Act this time, I had a friend of mine, I was even telling him, I said, you read the Electoral Act more than I did. So, people should be interested in reading the law and seeing it. Because some of the lawyers have noticed, don't read it. They assume that things are being the way they have been, but they have not been so. The National Assembly did a lot in the Electoral Act 2022, and we needed to get to it. The judgment of the Court of Appeal, listening to them, didn't show that they have read the Electoral Act as it is today.
All right.
Perhaps the address of the lawyers, both for Chinwo and those who are petitioning, the address to me, in some extent, didn't really show that they also have read the Electoral Act as it is today. So that may be a problem. And that has often been a problem.
Now, the reason why I asked these questions, to start our conversation, as we go to the Supreme Court, is because one would wonder if when you get to the Supreme Court, you can argue differently from how you argued at the Court of Appeal or, the Presidential Election Petition Court, and you can submit new pieces of evidence, or you can learn from your mistakes, or is it basically the same arguments that will be ruled on by the Supreme Court?
Yeah, the Supreme Court will deal with The Supreme Court will only deal with what happened at the court of appeal. That's why it's a court of appeal. He appealing against what the other person had and didn't act rightly on it.
Okay.
What he saw and didn't use well. What he handled and didn't use well. He allowed them to appeal against what that person didn't hear or see or handle. So it is evidence that was before the court of appeal and the law that was brought before it, that the particular evidence of fact that will come in. Of course, some aspects of law that are still applicable that may not have been used can still be brought in, but not the facts of the case. Nobody's bringing any new evidence. Nobody's bringing any new arguments based on those facts. So that's the way it is. So if they didn't, but you see, sometimes the court that had the case on trial may have evaluated the evidence wrongly. They may have concluded wrongly. So you are going to challenge their evaluation and their conclusion with the law and the Supreme Court. And if the Supreme Court agrees with you, okay, if they don't agree with you, if the Supreme Court says, well, those people are evaluated properly, or they handle the law, apply the law properly, then your appeal is dismissed.
Now, okay. So why we're talking about the Supreme Court is Umahi thinks, and I'm going to quote him now. If you give me a minute before we go for the next or our first commercial break, Umahi did say, as seen on Arise TV's website. I had it just now. I can find it all of a sudden. Yeah, is that Peter Obi has served the purpose of John the Baptist for the divine President Bola Tinubu. That is all that God brought him to do this time around. Clark thinks that if they go to the Supreme Court, they will not be able to win. Both Atiku and Peter Obi. Kwankwaso, who was also a presidential candidate after looking at the presidential election petition court judgment, also thinks in that direction. Now that you've explained that there will be no new facts entertained, maybe new arguments can be on the same issues. The question then is, what are the chances? What are the chances?
Again, that's what I'm saying. I don't have I've not seen the notice of appeal. I've not seen the brief of argument. I've not also read the judgment, entire judgment of the Court of Appeal. So it will be presumptuous for me to say their chances is very high or very low. What is his name? Omahi and so two of them are engineers. It's as good. It's like if I come here and as a lawyer to begin to talk about the strength of material, and then all those coefficients and the things that engineers will say. Everyone knows I'm playing in a team that I don't know anything about. Kwakwaso and what's his name? Umahi. They don't know anything about law.
But Robert Clark is a senior advocate of Nigeria. Robert Clark is.
I'm coming. I'll come to Robert Clark.
Okay.
I'll come to Robert Clark. I'm talking about I chose Kwakwaso and Umahi. Those two other engineers. So they should leave politics apart. Now, Robert Clark, in his interview in Arise, I watched it. He had his own view, and his view was that the matters were not properly presented. But I will still, if I were him, I would say, okay, were you at the panel? Have you read the petitions? Did you read the addresses? Did you weigh both sides? And of course, even if you did, that is not the cause. The same matter have been presented in the Court of Appeal. And the Court of Appeal finished their judgment and looks so fine. And the Supreme Court throws it out. And you'll be surprised at the picture of the Supreme Court judgment. The matter that brought Amnesty to the governorship of Rivers State, he lost at the Court of Appeal.
All right. Let me pause you now. Commercial break up next in a few seconds. So when we come back, ask you 2-3 more questions and then we'll open the phone lines, please.
That's all right.
All right then. Thank you.
Nigeria Info on
92.3.
Headline News.
The headline news: Governor Fugbara reads right. Listening to 92.3 Nigeria Info. We're live on Facebook, Nigeria Info page. We're live on YouTube, Nigeria Info page. We're active on X. You can interact with us there, Nigeria Info page as well. And we've been talking about going to the Supreme Court. The certified true copy of the judgment done by the Presidential Election Petition Court has now been given to the various parties who are seeking some kind of justice, so to say, and they are looking at it, and they would apply within the time frame to appeal at the Supreme Court. And so I've called in a very wonderful guest, a constitutional lawyer, Dr. C.A.J. Chinwo, and we've been talking, and we started by looking first at what happened at the Court of Appeal, and now we want to go to the Supreme Court proper. And you were talking. Welcome back, Dr. Chinwo, first of all. Before we went on the break, you were trying to respond to the comments by Robert Clark, who said that he does not see any reason as to why they should go to the Supreme Court, and you were saying a thing or two. So can we hear you now?
Yes. Yes. The point is that again is that when a lawyer or anybody is looking at the issues from a partisan perspective, it's also going to be limited in how he analyzes it.
Okay.
And be very careful not to look at it from that perspective, because I for one, for instance, I'm a supporter of P2B, but I try not to look at it from that perspective. Robert Clark actually is shown even before now he's a supporter of Chinwo, and he has right to do that. And I commend him for being, I admire him actually for even at his age, he's still active in the media, active in the public space, and standing for what he believes. But when it comes to analyzing issues as they will go to the court, I think we also need to have circumspection, because the court still thinks, for example, the Supreme Court is the policy court of the country. They see things from a different perspective. It may be just one thing, like I was mentioning before we cut off on the break. The Amechi matter, they lost in the Federal High Court, lost in the Court of Appeal twice, but the Supreme Court came out bold and made the pronouncement about Amechi's continue without contest of election. So the Supreme Court is capable of still saying there are fundamental things, fundamental errors have been made beyond what anybody saw. But let us therefore be circumspect in conclusion when it comes to these matters.
All right.
My elder brother of mine, who's a chartered accountant, once said that I know the result of Mexico, he said law has no bone. So nobody should think that he has to go, law can turn any direction, not because of lack of integrity of the law, but because the law, several factors determine issues or the decision of the court, and including that the secrecy of the justice. So it will be too long for anybody to say, don't go to an appeal, you will not win. Many matters have been said like that, we have went on to win. I bet you case, clear case, and many others will say for that matter.
All right then. So now let's talk about how the citizens view the judiciary, and that was our last conversation the last time you were here. How the citizenry views the judiciary. Now it's going to the Supreme Court, but before it did, the Court of Appeal were looked down on by the citizens. You know, a lot of them said, "Oh no, what kind of a judgment is this? We don't agree with you on FCT. We don't agree with you on, you know, certain issues." And like you've explained, it's not about sentiment. It's about how you argue your case in the court and with the facts that you submit in the court. How do you think the Supreme Court can win over the citizenry and have them believe in them?
So I think that's the last bit.
I said, how do you think the Supreme Court can win the people over and make them believe in the judicial system?
Well, the Supreme Court or any court for that matter doesn't set out to win people over. What the court does is it goes out to decide matters that are before it, because the people who affect us are the people who are before the court, the parties. And they want justice according to the law.
Right.
And the court can only do justice according to the law, not beyond the law. You know, I've said it before, I say it again, Nigerians should be more interested in the legislation, the statutes, what the laws that are passed in the House of Assembly and National Assembly. Because that's where the harm is done. The Supreme Court is only to interpret that law and apply it to facts of the case. So the Supreme Court will not start out to go and be popular. That's I mean, the
but it's not about
doesn't go out looking for popularity. If the court starts out, the court has already gone into a disastrous lane.
Now, Dr. Chinwo, now, it's not necessarily about popularity, but like I said, you've seen how the judgment from the Court of Appeal has been greeted. Like you've argued, it may be the truth, it may be the reality of the judges, it may be the reality of how the case was submitted to the court. It may be, I mean, different factors could have contributed to how the result or the judgment did come out. But the Court of Appeal has been, and the justices have been the ones who have bore the brunt. And I'm asking you, and I'm saying, what do we do so that when the judgment does come out, even if not everybody still believes, a larger population would say, okay, looking at the merits of the case, maybe the Supreme Court is right, because it can tilt anyway, like you've said.
I think what we should do is not get interested in the proceedings of the court. For instance, I think the proceedings of the Court of Appeal may have been uploaded online, or people can apply for the certified copy of the entire proceeding and then of the judgment. I know it's heavy, it's big. I don't know how many people can spend time to read it. But if Nigerians begin to read the judgment, all reports are being sold. And I tell Nigerians, I know it may seem like you have not solved the immediate problem, but the time we begin to show interest in reading the law. You don't have to be a lawyer to read the law. Because that's what governs your life. That is what affects you. That's what determines who you are, what you will come to be.
Right.
So let Nigerians get interested in reading. So when you read proceedings and law reports and see what happened, you'll be able to analyze. And then when the judgment matters are being before the court, if we can detach ourselves from our emotional attachment, we may be able to know when the court is saying what happened.
All right.
Because in our day-to-day life, matters arise and emotions go high. But when people sit back and begin to present their case, you begin to realize that those as we saw before, many people have died in mob action. Who if people need to truth, they won't regret that. Why did I get involved in this? We have killed an innocent man. It also happens in litigation. And in saying this, I'm not vouching for all judges. Let me say it again. There may be judges that are incompetent, there may be judges that are corrupt, there may be judges that are lazy, but they are a small proportion compared to the entirety of the bench. And of course, the politicians have done us greater harm with the people they have appointed to the bench. But see, when they are appointed at the high court level, people don't talk. That's where it starts. A man is appointed to the high court. The president is carrying wine and yam to the governor. Thank you for appointing our son. You have not asked whether your son is competent. Thank you for appointing our daughter. Is she a competent person to be a judge? You don't bother. That person will be promoted to the Court of Appeal. One day that person will go to the Supreme Court, and it is too late to stop. So let's get interested.
Right.
crying over statistics. So the Supreme Court will do its best, and I wish that the lawyers will present their matters as they ought, and then they should be properly reported. And when they do, the judgment will come. I wish the Supreme Court also will confirm and give judgment according to the law.
Should it be televised? Should it be televised? Someone just said something about it being televised. Should it be?
Well, I don't know why the courts are shy of matters being televised. When the matters are issues that proceedings are being televised, the public is not talking into television. Nobody can ask the proceedings. As the televised judgment, why can't you televise proceedings?
But you know what they say. You are legal personnel. You know what they say. Do not preempt the court. Will that be possible when it's being televised? Would people not do it like it's a bet or something?
When there is rumor, when matters are not televised, rather in the public, cost increase. The equality said that when we share in the system, they said that the first one has taken off. But when we share in the open, we find that the first one is even the one losing.
All right.
So televise it. Let Nigerians see. Let Nigerians have seen what the judges were saying. They would have been able to say, oh, this one did well, Atiku's one did well, or didn't do well. They'll be able to know that the one man, what you came out to tell the press man, it's not what happened in open court. But you see, nobody knows. Now you have left it to only 5 judges to come and make those comments. And people are saying, if it is so, why didn't you let us see it? So I don't know why the proceedings shouldn't be televised for those who can afford it. Because what happens is that make it public. I don't know why judges want to hide their face. They want to hide their judges. Okay, don't show the faces of the judges. But televise it. Why shouldn't you? Why is not so? Criminal matters long ago in England. Where we got it from? They are televising public matter, criminal matter. I don't know why we are so secretive in our nation.
Right, then.
And long ago, an English judge said that justice is not a clustered virtue. So we're making it a clustered virtue in Nigeria. So that is the problem. I wish the Supreme Court can say, okay, for the sake of the interest of everybody, people are so interested, let us televise for the time the matter is mentioned in the Supreme Court until the death judgment is given. And I'm sure that may be, like you said, that may be something to be done to redeem or change people's perspective of the judiciary. There's nothing, I don't like this secretiveness that's all about our proceedings.
All right.
Not only the judiciary, executive, our budgets are not publicized. National Assembly is shy of publicity. We cannot continue in this clustered way in Nigeria. We must be open and open society.
All right, then let's open the phone lines now, please. 0817-923-0002 and 0817-923-0003. WhatsApp 0809, I beg your pardon, 0306416. I've got Dr. C.A.J. Chinwo, and we're talking about going to the Supreme Court. But Doc, before I take my first call, if we do televise it, would people be able to understand? Because I mean, some of us watched the judgment given by the Court of Appeal, and a lot of people found it, somewhat cumbersome in terms of comprehending what the judges were saying.
Yes.
Did you get?
So that's also,
okay, go ahead.
Sorry.
Yeah, go ahead.
So what's the question?
No, go ahead. That's the question, actually. Go ahead.
So it's the question now. It's saying, when people are saying televised, they will find it very daunting. They'll get tired. Because see, we lawyers know what to suffer in court every day. And then the procedures and the arguments back and forth. The same Nigeria will say, is that what they're doing there? Why are they just arguing? So that what will happen. So people will get tired. Many people tune off the television, went to the market and came and they see there. So you find that it's only those who are interested and still interested.
All right,
but I think why they should televise it. Let Nigerians see what they are saying. Because when the client comes to court, he appreciates what his lawyer is doing more than when he stays in the office and says, go to the court.
All right.
But when he comes to court, he stays in challenging the lawyers are facing. The attitudes change. He even see what the judges are facing. The attitudes change. In many cases, we need to advocate for the judges. We managed to see the Court of Appeal court where they are sitting. Currently lit. Many courts in Nigeria are not even badly lit. All kinds of things. Like atmosphere is very poor for working.
All right.
So they should televise it. Let the whole Nigerians see what it is.
All right, let's go to the phone line. I've got Jude from Omuma. Jude, greetings to you. Welcome. What's on your mind, please?
Hello, there. Good evening.
Yeah, good evening to you.
Yeah, Dr. Chinwo, I have a question regarding the Constitution 1999 and 1999 as amended. The justices said on the 25% of vote cast for FCT. It's in the Constitution, like I said, 1999 and 1999 as amended. It has not been expunged. I guess some of the lawyers base their argument on the Constitution. And now the justices are now telling us that the lawyers are wrong, and then they now have to give it interpretation of their own. Not the Constitution has
so do you know what do you Jude?
So how do you see that?
All right, Jude, thank you very much for your time. I hope you can hear. But when you said the Constitution, I want to jump in on this one because there is the part that says, Abuja does not have a special status as mentioned by the judges, and I'm looking for that part of the Constitution. I had an argument earlier on social media and I screenshotted it. I beg your pardon. It says, I think, part 1, chapter 8. I don't know how you guys read the Constitution, but there's a part that says the Federal Capital Territory Abuja shall be the capital of the Federation and seat of the government of the Federation. The provisions of this Constitution shall apply to the Federal Capital Territory Abuja as if it were one of the states of the Federation, and accordingly. And then it says all the legislative powers, the executive powers, and the judicial powers vested in the House of Assembly, the governor of a state, and in the courts of a state shall respectively vest in the National Assembly, the President of the Federation, and in the courts, which by virtue of the foregoing provisions are courts established for the Federal Capital Territory. Does that answer the question? I'm wondering, Dr. Chinwo.
Well, the point that, these matters are matters of opinion, and my own opinion seems to have, even before now, aligns with that of the Court of Appeal in this matter.
Okay.
Because I believe that when they said treat FCT as if it's a state, it's like saying 37 states. The issue is the Tinubu call, whether legitimately or whatever, however they got the vote, like they did in River State. Did this court 25% in 2/3 of the 37 states? It wasn't be a particular state.
Yeah.
It wasn't that you was mentioned River State or Lagos State or Abuja or Kano. It's 25% of 2/3 of the state. So if you have 25% of 37 states, then to me it has met the requirements. So that is the point. And then if you have the majority of the votes cast,
all right.
So that's where I've been. That's where I still stand, and that's why I understand by that provision. But if there are contrary things to bring out will say, particularly the approach to election. Because you see, I recently read again the Owodowa Shagari case in 1979. The courts, when they are coming to interpret electoral matters, face the issue of public opinion that is often not founded on the law and not even founded on the facts. But the courts have to be as disposable as possible, because knowing that Obi and Atiku have their own supporters, Tinubu had his own supporters, SYZ had their own supporters. So everybody's a Nigerian. The court will have to decide what to keep. Ensure justice and ensure peace. So I don't advocate that peace should, but issue of peace should be the deciding factor. Justice should be.
All right.
But the courts have all these considerations in mind in arriving at what is considered a perceived to be justice.
All right. I'll pause you now. I've got callers. I've got Real Gift from Port Harcourt Township and Braid from Buguma. Let's start with Real Gift. Real Gift, what's on your mind, please?
Good evening, Tim K. Good evening, Doctor.
Yeah, greetings.
I want to come on the angle of, is it on the issue of the Supreme Court televising the proceedings?
Generally, we're looking at going to the Supreme Court. We touch on several issues, please.
You see, there is no need for a chicken admiring the corn inside the bottle. Because even if they televise it, we know what happened there. There is a difference between the person who cooks soup and somebody who adds salt for that soup. Because we might watch live proceeding, at the end of the day, it is still the judges, the justices that will still take the decision, not be me and you. We watch. Is it not? So for me, I don't think the issue of televising it live is an issue. Let justice be done. That is where I have my own issue.
All right.
Thank you very much.
Real Gift, thank you very much. Braid from Buguma, welcome. What's on your mind, please?
Yeah, greetings to Canada.
Yeah, greetings.
And to the guests in the city.
All right.
Yeah, my question number one. does it mean that the justices of the court will tell me that Nigerian Constitution say that if there is any manslaughter or unnecessary killing, does it mean that the whole body will be taken to the court?
Brad, we can't hear you. Brad, we can't hear you.
Can you hear me?
I can hear you now. Go ahead.
Yeah. Does it mean that if there is a killing somewhere and the matter gets to the court, does it mean that the lawyer must bring all those dead bodies to the court to satisfy that yes, really there is a killing? That is number one. Number two, why the judges refuse from televising the proceedings when it is judgment? Because that time they said they are not Nollywood. How would they revise it?
Brad, I'll have to let you go. Unfortunately, the network is terrible. Dr. Chinwo will get to react to you shortly, but first let's read some messages, take one more call, and then we'll wrap things up. Greetings, Kalada. Anybody who still argues about 25% vote in Abuja should read Section 299 of the 1999 Constitution as altered. Abuja has no special status. Emi Fiaga, I think they just tackled that one. This one says, greetings, Kalada. Greetings to Dr. C.A.J. Chinwo. Tell him okay. They said they miss you. They said I should tell you they miss you. Come back to Port Harcourt. They miss you. Yeah, they say we are in Nigeria. We're watching the Supreme Court to give us a favorable judgment. TK from Port Harcourt. This one says, as a layman, I understand that the law is, I don't know what you wrote there. I can't use that word on radio. Is it the ARSC you're talking about? But you said, but in the case of Nigeria, the entire judicial system is more of, okay. Ben, I'm sorry. I don't know what you're trying to say there. But moving on, good evening, Mr. Kalada and Dr. Chinwo. Doc says we all should be satisfied with what comes out after 12 judges, 5 appeal judges, and 7 Supreme Court justices have gone through presidential polls legal proceedings. Agreed, as that is the standard practice. However, if 4 of the 7 Supreme Court justices were to upturn any of the unanimous rulings from the Presidential Election Petition Court, and 3 justices agree, it would mean that 4 justices disagreed with 8 judges, yet the 4 judges had the final say and their way. Kind of unfair, but very legal. Text from Oyigo with technicalities there. Muriel is calling from Okrika. Sorry, I forgot. Muriel, welcome.
Thank you, Kalada. Good evening.
Yeah, greetings to you.
You see, Kalada, I've always wanted to be a lawyer, but now I'm beginning to thank God for UST giving me another call. Look, Kalada, I listen to your guest up to a point that my head wanted to turn, and now decided to shift the radio a bit and move back. Because I don't know whether he's trying to confuse me or confuse, because the information were too much. Now, Kalada, courts and lawyers contradicting themselves. What is happening? I thought in law is maybe this versus this, cases that have happened and they set precedents, and they will not use that as judgment. They will not be basing their judgment based on those precedents they set. But different lawyers will come and counter those precedents, set another precedent, counter the precedent, set another precedent. So those that are heading to the Supreme Court, Salada, the lawyers in the Supreme Court, are they going to call the lawyers in the tribunal or the lawyers in the appeal court liars? Will they tell the lawyers in the appeal court, okay, based on this evidence in front of you, black is no longer white, white is now blue? I don't understand, Kalada. So I'm waiting and hoping to see the lawyers in the Supreme Court calling the lawyers in the appeal court and the tribunal liars.
You mean justices, or are you talking about justices or lawyers? Because it might just be the same lawyers. Are you talking about justices or lawyers? Because it might just be the same lawyers for the parties.
Please, can you speak up a bit?
I'm sorry, I would have to let you go. Network issues there. We've got another commercial break. Dr. Chinwo, I would ask you to stay put for the now bin. When we come back, we get your final words. And I do have a question. Maybe you can begin thinking about your answer. If you were to be the lawyer for any of the petitioners, what would you do differently? So when we come back from the break, I'll take your thoughts and then we'll wrap things up.